Hello friends, in the series on income tax cases, today we will discuss a very important case, and the case is related to that if some assessee receives some gifts on the occasion of his marriage, but the gifts which the assessee receives are being credited into his account after 10 or 15 days of his marriage. So whether the addition can be made by the assessing officer just on the basis that the gifts are not received on the occasion of the marriage, or in simple words, whether the relationship between the gift and the marriage is to be seen, or whether the timing of the gift is seen. This issue has been decided by Mumbai ITAT D bench in the case of Dhruv Sanjay Gupta versus Joint Commissioner of Income Tax, and this case is reported in 134 ITR Tribunal at page number 424, and the date of the judgment is 20th June 2025. The present case relates to the assessment year 13-14. In the present case, the assessee marriage was completed on 8th December 2012. The date of the marriage of the assessee was 8th December 2012, and the assessee received two big gifts from two persons A and S. The first gift was received from a person A of rupees 2 crore, and the date of the check was 8th December 2012. This check cleared on 18th December 2012. When the assessment proceedings were going on, the assessing officer noticed that on 8th December 2012, the balance in the hands of A, who has given the gift to the assessee, was very meager, and before the amount was transferred to the assessee on 18th December 2012, A received some amount from P and some amount from D, who was the grandfather of the assessee. The assessing officer also noticed that as soon as the amount was credited into the bank account of the assessee on 18th December 2012, immediately on the next day, that amount was transferred to his grandfather D. So on this basis, the assessing officer made a view that these were the transactions which were just done to build up the capital of the assessee. So he said that the gift is not at the occasion of the marriage because it is not received on the date on which the marriage solemnized. As far as the second gift was concerned from S, the assessing officer made inquiry from the bank by sending the notice under section 133 subsection 6, and the bank intimated to the assessing officer that it is an advance export proceedings in the hands of the S. So the assessing officer made a view that this gift is also not genuine. But basically the apprehension of the assessing officer was that these amounts are not being credited on the date of the marriage. They are being credited some 10 days or 15 days later after the marriage. So these are not at the occasion of the marriage. The CIT appeal also upheld the order of the assessing officer. So when the matter was before the tribunal said that for proviso to section 56 subsection 2 clause 7, what is important is that the relationship between the gift and the marriage and not the timing of making the gift. The tribunal said that it is to be seen that when how the assessee has received that amount, if that amount has been received in lieu of the marriage of the assessee, so even if that amount is not received on the date of the marriage, even then that amount will be exempt under the Income Tax Act. The tribunal said that in the present case, the assessee is very much able to demonstrate to the assessing officer by providing the financial statements of the donor A and also providing the bank statement of A. So in the present case, it cannot be said that the amount has been received just to build up the capital. It is very clear, and there is no doubt that the marriage of the assessee has happened on 8th December 2012. There was no doubt about that. So in the present case, according to the tribunal, the assessing officer has taken a very microscopic view and very unrealistic view that the amount on marriage should be received on the date of the marriage and not after that. Friends, this case is very important because the assessee cannot keep the track that when the marriage is happening, so that amount is credited on the date of the marriage or not, or some people may come even after the date of the marriage, which are coming from outside India or some other places, and they can give the gift to the assessee. So whatever the gifts are received on the date of on the occasion of the marriage of the assessee, so all that amount is exempt under the Income Tax Act. At the end of this video, once again I am repeating the name of the case. The name of the case is Dhruv Sanjay Gupta versus Joint Commissioner of Income Tax, and this case is reported in 134 ITR Tribunal at page number 424, and the date of the judgment is 28th June 2025. Thank you, friends.